Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. We welcome students before we call the case. Welcome students. What school again? There we are. Yes, sir. Okay. Thank you for coming. Thank you very much for coming, and we'll have a chat here afterwards. And I didn't recognize earlier, but one of our honored retired colleagues, Judge Jack Wesley, is here with a young woman, Afghani woman who's a sophomore at Dartmouth right now. And your name again? Yep. Very nice to have you here as well. All right, so please go ahead and call the case.
Good morning, Your Honors. The matter before the court is the case entitled Melanie Centeno versus Rodney Centeno, case number 23AP275. Representing the appellant, Rodney Centeno, is Mary Kirkpatrick. Representing the appellee, Melanie Centeno, is Jacob S. Oblak, seated at the council table with Melanie Centeno.
Thanks very much. Good morning, counsel. We'll hear from counsel for the appellant first, of course. Come on up, please. Please introduce yourself and identify your client and then proceed.
Thank you. May it please the court. My name is Mary Kirkpatrick, and today I'm representing the appellant, father, Rodney Centeno, who's sitting right here.
Thank you very much.
We are appealing a trial court decision as to custody, specifically a finding that the father risked and actually caused harm to the psychological growth, development, and welfare of the children in this case. This finding was clearly erroneous, not supported by the evidence, doesn't meet the statutory factors for emotional maltreatment of children, and should be reversed.
So, Ms. Kirkpatrick, before you address the merits, there was a motion to dismiss filed by appellee, and I know you opposed it. We both cite Oregon, and I guess I'm having trouble understanding why the final order, as a court, the lower court, identified it for parental rights and responsibilities as Oregon states. This court has repeatedly held the test of whether a decree or a judgment is final is whether it makes a final disposition of the subject matter before the court. So the subject matter before the court was a contested divorce. That tells me there is not a final judgment. So perhaps you can elucidate and tell me why you believe there is a final order. And if you believe there is a final order, how does that reconcile with Vermont Rule of Civil Procedure 54B?
Well, Your Honor, the trial court found and wrote that the court was issuing a final order on that portion of the decision dealing with parental rights and responsibilities. So that is, from the court's point of view, a final order as to the parental
And
rights.
if the court didn't follow 54B, is that fatal to whether or not it is a final order?
Well, Your Honor, it is final now.
Now, not at the time that you filed your appeal.
So
That was opposed by mother.
correct. Citing Horgan, which
I
had to deal with
Yes.
whether or not mother should have taken should have treated interim decisions that were not final as final and have appealed them.
And I just cited
Yes.
Horgan to you. Which Horgan holds under this court, the test of whether a decree or judgment is final is whether it makes a final disposition of the subject matter before the court.
Well, so, and it's our position that given Judge Carlson's statements, that it was a final order. He states it. So moving along, we do not think that the statutory factors for emotional maltreatment of children is met in this case.
Ms. Kirkpatrick, would you agree that on the parental rights responsibilities as a fairly close case? parties were not going to agree to shared custody. That was clear. So the court has to make a decision based on the criteria. And somebody was going to be the custodial parent and somebody was not. And so it could be a small thing that could make a difference on tipping the scales to one parent or another. Isn't that what the trial court did in this case?
Well, Your Honor, it made a finding of abuse, that the father had been abusive. Not only is there reputational damage relating to that, it's a finding under Title 33, which is the definition for also placing people on the registry. This is a father who works with children all the time as a swim coach and a club manager. When there's a finding, and here it was under 665B of abuse, that tipped the scale. The trial court had lots of comments about how equal these parents were.
Right.
And this tipped the scale. And not only that, the judge used very prejudicial language in terms of a coup by father,
What
which
did you think
is,
he meant by the coup? I didn't have a hard time figuring.
I just found it very, very prejudicial because neither parent at the time in the summer when they're arguing in California had more rights to these children than the other. And so just because father had a plan and mother had a plan that was in conflict with one another doesn't mean it's a coup. Father knew that there would be a divorce if mother didn't agree to keep the children in California, where he had a much better job. There was no housing in Vermont at the time. Their lease had expired. He knew that if they couldn't agree, there would be a divorce and that the judiciary would have to make a decision. That's not a coup. A coup is an overthrow of a government, and it's not where a parent is looking to the judiciary to make a decision about who's going to have parental rights.
Wasn't
To move, oh, go ahead. To move back a minute to the abuse issue. As I read things, the events themselves are not really disputed. It's the court's characterization of those events as being abuse that your client is taking issue with.
Absolutely, Your Honor, because abuse under the statute 334912, it's a definition, right? And it requires three things for emotional maltreatment. It requires a pattern of behavior, which is a repeated pattern, right? We all know what a pattern looks like. There was no pattern here. It also requires maliciousness, and then it has to show impaired psychological growth and development, not just an adverse circumstance of divorce, right? But it has to show that it's a permanent, impairment of psychological growth and development. And there was nothing like that in this case.
On the malice issue, didn't the court find that the father, in fact, was well-intentioned?
Not only that, was well-intentioned, and that he believed it was in the children's best interest, because in California, he could earn 2.5 times what he could earn here and what the mother was earning, and could provide a much better life for everybody. So it was the father's intent to create a viable plan and then convince mother of it when she got there in California. And the discussion that they had on the beach, taking a walk on the beach, was between themselves when he said, there's going to be a divorce. I'm not going to allow you to take the children back. I don't agree. And, a court's going to have to tell me. That doesn't sound like a military coup to me, or any type of coup.
One thing that I was struggling with in my mind was you had quoted that there needs to be a finding of psychological growth and development being harmed. Do you think that requires expert testimony?
In terms of, in this case, right, the harm to the children, since both parents had been involved, right, some of the facts that mother learned were after July, in terms of the father having signed a lease or having enrolled one of the children into school out there. That's different than also mother's reaction to father's position, which then caused her to run away and lie to the son about where they were going, and then to take off with the child. So
But then he called.
In
the
this
police.
case, I think that if I could just
Yeah,
finish, in
go
this
ahead.
case, I
Go
think tying the impairment of the psychological growth and development, if it even existed, because the children were on the mend and doing well in all other ways, there would have had to be something to tie it to whether it was father's behavior or mother's behavior. Right? Because by the time of trial, mother had also slapped the boy in the face. So who knows? But what we do know is that the children were doing well in school. If this finding of emotional abuse is reversed as clearly erroneous, and the trial court has to re-weigh all of the statutory factors, including the physical hands-on experience that had happened for the oldest son, there may be a different outcome. But in any event, this finding is clearly erroneous. In terms of the what the children knew versus the mother, the children only had experienced the fact that their parents were in conflict of whether or not they were going to live in Vermont versus California. And that had been going on for over a year. But they were certainly aware of it during the summer of 2022. And they had a long history in this area and county of California where the father was working at the time. So they knew their parents were in conflict. The son had overheard an argument where father had said to mother, "Don't talk about the return to school." And then the conversation had ended. They had seen a potential house where they might live because, again, father was trying to get things organized so that he could present this plan to mother. You know, they knew what the schools were around and that they might be able to go there. Then there had been the argument at the breakfast table where mother had been crying and father had said, she's having a breakdown, an emotional, mental breakdown. Let's call a crisis center. And he goes and he calls out on the porch. And then there's a fight when they get back in Vermont in front of the children where allegedly he says, you abducted the daughter and abandoned the son. Anyway, they're in conflict.
There were a lot of accusations, though, there were a lot of accusations that went around here. And can you explain the situation involving calling the police on the mother and the daughter who were at the airport? And again, like you were saying, there's nothing precluding that at this point.
So
Doesn't that rise to a certain level itself?
Well, Your Honor, what happened is that the mother left a day early, having told the son a fabricated story with the daughter. When the son, when there was no arrival at the meeting spot after he got done from work, he's tried to call the daughter, the phone's cut off, and he is worried and he wonders if the daughter has left voluntarily. He can't get in touch with anyone. And yes, he calls the police, he goes to the airport, and he tries to find them. And eventually that night, it turns out they're in an airport hotel room and the daughter is interviewed by the police, a female police.
And then allowed to leave, go to Vermont.
And then they left for Vermont. And the police assure the father that the daughter's okay. He hasn't been able to speak to the daughter. They assure him it's okay. Because the statutory standard for what is emotional maltreatment of children has not been met in this case under either of the three requirements, that finding needs to be reversed. Once it's reversed, it's not harmless. And this court can reevaluate the standards under section 665.
Would you please expand on, I realize you're trying to guard your time here. Would you please just expand on why you think it's not harmless?
Well, Your Honor, because the findings by Judge Carlson were that the families were equal, but for the incident, meaning what happened in July. Had that not happened, they would have been equal, and he would have had to dig down deeper to figure out which parent was going to get the custody. It is not harmless because it is such a negative finding, having abused your two children. Excuse me. Thank you.
Okay, all right, thank you. We'll hear from counsel for the FLE. Now, please introduce yourself and your client and then proceed.
Thank you, Your Honor. May it please the court. My name is Jacob Oblock, and I represent the appellee, Melanie Centeno. 15 VSA 650 is often raised in family appeals as it focuses on the legislature's policy of maximum continuing physical contact. But it's equally important, the other piece of that statute, which says equally maximum continuing emotional contact as well. And that's between the children and both of their parents. This case presents this court with a carefully planned destruction, or at least attempted destruction, of that relationship between a primary caregiver and at least one of the two children, if not both. And I've heard some of the arguments in the brief and today from the appellant's counsel. I would briefly touch on what the court raised as far as the finality of a judgment. I think Horgan referenced Morissette, that's 1983. And if my memory serves, Morissette had to do with a similar fact pattern to this case, where the one piece of a divorce was final, another piece wasn't. And so what I would agree with the court if it believes that there was not a final order when this was appealed. That is true in our opinion. As far as the merits, I can even also start with the harmlessness of the abuse finding in the event the court disagrees with the abuse.
Before you move away from
Of course.
that, sorry, I'm a little late with this. Are you suggesting that the court's not empowered to issue partial finals?
The trial court?
Yeah.
Oh, the trial court is empowered to issue partial findings. I think that no matter what Judge Carlson entitled his opinion, it is a decision on parental rights, responsibilities, and parent-child contact. It does not finally conclude the divorce, so there's no appeal of right out of that decision until the rest of it has been adjudicated. I suppose that the appellant could have asked for an interlocutory appeal. I did not see a request. There may have been another method of getting before this court, but it was not appeal as of right under Rule 3.
But Judge Carlson did say in his order, it's a final order
Yes,
on
and
parental rights.
as to parental rights and responsibilities and parent-child contact, even agreed that was his final decision, but that does not make it a final order under Rule 54.
So Black, you do a lot of family court, and especially on the last 4 or 5 years, where cases get dragged out a long period of time. Don't you think it's in children's best interest to get an appropriate parenting plan in place as quickly as you can? You might not be able to get to the property maintenance and the other issues that come up in a divorce case, but to have a plan in place for the children as early as possible, for child support purposes, for finality purposes, is in the children's best interest.
So as far as the best interest, Your Honor, I don't know that Rule 54 kind of incorporates a best interest and additional analysis. However, I understand the court's concern. I think that this case might be sort of anomalous in the fact that it took 3 hearings over a very long period of many, many months. It could have been 12 months. Maybe it wasn't that many, but it was quite a bit of months to get the parental rights piece done. And then we just had one more hearing on the property, and then there was a final order. And again, as the court knows, the rules don't require family court to house all of its judgments into one document like the civil rules do. So I think that the rules are clear that was not a final appealable order. It was a final decision with regard to parental rights responsibilities, but it was not an appealable order as of right under the rules.
So if we agree with you on that, then what happens?
I think
Because the rest of the issues have been decided now, correct?
The rest of the issues have been decided. I did not see a notice of appeal after the final order was issued. And I think it was issued long enough ago that time has run. So I think the court could not address the merits and could dismiss it on that basis.
So too early and not at all.
Correct. If the court wished to do that, yes. As far as the merits, I still agree with, if the court is considering whether there was, well, actually, what I would say, Your Honor, is it was not an equal playing field, even taking the abuse finding out. It was not an equal playing field. The court specifically referenced primary caregiver, that the scales tipped in my client's favor. So that the court, based on all of that, all of the factors, as described by Judge Carlson in his very detailed order, was awarding my client sole parental rights and responsibilities for many reasons, one of which was abuse. But again, there were other reasons that he.
So are you saying the abuse finding, if it's error, is harmless error?
That is our argument, yes, Your Honor. We believe that's harmless. Yes.
So let me ask you this question, then, Mr. O'Block. If you're finding that if there is abuse, it's harmless, that changes the standard of review. And in my reading of appellant's brief, it is an attack on statutory interpretation. So why isn't it de novo? The standard of review.
The standard review, sure. Excellent question. I did consider that, Your Honor. I think that perhaps if the definition of abuse is in question, that's an issue of law. The court decides de novo. However, the trial court's application of these facts to it is discretionary and affords great deference to the trial court's analysis of both the facts and its application to the definition. And this court has, in cases cited in our brief and in other cases, this court has intentionally left, the legislature has intentionally left definition of child abuse broader and less curtailed than I think the appellant wishes it to be. The definition of abuse between spouses or family members, that one is much more curtailed under Title 15. And I think that was intentional by the legislature. And what this court has said on multiple occasions is the definition of child abuse is a bit broader than that, much broader than that, quite frankly, so that we can make sure that we do what's best for the children and make sure that we are able to address abuse as it's occurring and prevent it in the future. And in this case, the trial court's findings are very clearly rooted in the facts. And I can briefly address intent. It was raised by appellant. I don't believe that the malice prong of Title 33's emotional abuse requires intent to cause the harm that was caused. That is not even under tort law. Apologize, right? Even under tort law, that's not the only way to get to malice. I mean, this court has held in tort cases that it can also be recklessness. Reckless disregard of the likely consequences are egregious.
It's a matter of degree.
It is a matter of degree. And I think that this trial court found very clearly that in his view, in the trial court's view, the fact finder, that this was egregious behavior in his view. He explained
It was the plan that he found to be egregious behavior, the fact that the father's plan was such a way. But where are the consequences of the plan? Where was the evidence of consequences of the plan to the children affecting their psychological growth and development?
Sure. And so I would, as far as the impairing the psychological growth and development, I don't think it needs to be permanent as was suggested today. That's not in the statute, and I don't think that's what the legislature intended. I think that there were many witnesses that detailed the trauma that resulted to these children as a direct result of this plan. Even fathers and witnesses detailed how traumatized the children were. I would point the court to Mr. Baker. He testified on November 4th, 2022, page 165. He referenced how it was negatively affecting the children emotionally. Ms. Natoli, father's sister, same day, page 188. The son, quote, collapsed in her arms, unquote. Page 191 in the transcript. It was a tragic day for her. I'm sorry. It was a tragic day for her, and it was a very traumatic day for the son. Even his own witnesses agreed that the children were traumatized.
But isn't trauma to children something that occurs frequently, if not always, in a divorce situation? It's people are on the ragged edge, and the children are exposed to it. Where do we draw the line?
I think that it's possible. I don't know that it happens in every divorce, but I agree that the court has to draw a line. What I would say is that the definition has to hew to the Title 33 definition. So we're really talking about a pattern of behavior that is malicious and that results in psychological impairment or risks such. And
doesn't that last piece require some expert testimony?
I don't think it needs to, Your Honor. That doesn't. I do not believe that's not a requirement under Title 33's Chin's abuse definitions. It's, to my knowledge, not been a requirement under any of these definitions. It may be helpful, but in this case, all of the witnesses agreed the children were traumatized. It didn't require an expert for either everyone's witnesses or the trial judge or anyone listening to the case to realize this relationship is.
But isn't that word thrown around a lot, traumatized? I've heard of teenagers saying they were traumatized because they couldn't find the clothing that they wanted online, So what is traumatized and sorry for the teenage girls. I wasn't referring to any of you.
Well, there's a nod in the back from a parent, so I don't think we can pick out the.
But how does a layperson say, oh yeah, I saw that child and he was traumatized? I mean, what does that really mean? And don't we need someone with a little more expertise to really explain that this child's psychological growth and development was being impaired by this?
I agree that would be
Does any of, when you say the child, you mean the son?
I'm specifically referencing the
And
son.
does any of that have to do with the mother's actions, which I'm not questioning because it was a really difficult situation? But, I understand he was really upset by being left behind, and wasn't there, maybe not even equal, but wasn't there issues that hurt that child on both accounts?
I don't think, and the testimony I think bears this out. I don't think that if my client could go back and do it again, she would try her best to make it better for both children, really. But in this case, we're talking about the son. Whether or not that contributed to the trauma the children experienced may or may not be true. And in fact, the trial court could probably, well, he made a finding that was very close to that. So that is within the trial court's purview, just like the trial court's discretionary decision as to whether or not the father's actions were abusive, emotionally speaking. What I would say is that whether or not another person is also doing things that contribute to the abuse or to the trauma, I don't think that can negate what party, actor number one has done to those children. So we could find, so for instance, if there were, and I don't believe this is the case here, but if there were two individuals who had emotionally abused a child, the fact that one of them did, and then also the other one doesn't negate the first one, is what I'm saying. I don't think it's exclusionary. So the trial court I don't think we're on appeal here on a factual finding as to whether or not the trial court should have found that my client did or did not contribute, or that's not here on appeal. That's a different question. The question before this court is, did Mr. Centeno emotionally abuse the children?
And does it matter, Mr. Oblak, that that the email that was admitted has language or admissions by father that if mother doesn't choose, quote, help and healing, close quote, by letting the kids stay in California, then an ugly chapter would result. Does the content of that email matter in this court's analysis of regarding the maliciousness and abuse under either 3349? Well, we're not dealing with 1105 because there's no physical abuse here.
Correct. I do think that letter should be analyzed by this court in answering the question of 4912 emotional abuse.
And tell me why you think it matters.
I think it matters because this evidence is an entire setup that his father had taken over the last many, many months to create the very situation that placed mother in that Hobson's choice and gave her no valid options to not contribute to the traumatization of the children. He engineered the entire thing.
But so what? So what? I mean, he's trying to be a parent. The rules aren't set yet. He's trying to do the best he can with what he has. He's going to figure he might prefer the California schools to the Vermont schools. I'm not sure why that has become such an important issue when nobody had given the parties, and the parties certainly weren't going to come up with a parenting plan on their own. So somebody got to do something.
Someone had to do something. So he should have filed, perhaps. That probably should have been.
But does it matter if he acknowledges that it's going to cause trauma to the children? Essentially, that's how I read that email.
I agree that matters. It matters to me that not only did he acknowledge that would cause trauma, that was his testimony. 2 different points in the hearings that he knew it would cause trauma and he bowled on ahead anyway. That is where I get back to malicious, is because it is, and I apologize.
Now finish your statement.
The thought. It is the reckless disregard of the consequences he knew would flow from his plan, his scheme. And they did flow from that scheme.
All
Thank
right,
you, Your Honor.
thank you very much. How much time does the appellant have, please?
Your Honor, appellant has 2 minutes and 15 seconds remaining.
All right, counsel.
Your Honors, divorce, breaking up of a family is traumatic for children in the sense that it is an adverse circumstance affecting their childhood. However, it is pretty ordinary. It's also pretty ordinary for parents to maneuver or manipulate to try to get the children into one school or another, or to, plan what they think might be best. That's all that happened here. And to stretch that into the definition of abuse under Title 33, if that's the court's finding, well, then there's going to be a lot of parents who are guilty of emotional maltreatment of their children when they're going through a divorce. And it would change things a lot. I also think that there should have been some forensic expert testimony as to what was the cause, what was the effect the children were on the mend, and was it mother's reactive behavior and lying to the child that caused the rift in their relationship. Notably, the daughter never had trouble, and notably, the father never had trouble with the son.
So, Ms. Kirkpatrick, did you file a motion for expert testimony in this?
No, I did not. No, neither party put in expert testimony. The child did go to a therapist, both children, and neither invaded that privilege, and there is no expert testimony tying or even finding impaired psychological growth and development.
But your
We
client did use in the email that was on the family laptop, did use the word trauma. That it's going to be traumatic to the children.
It was going to be stressful. I thought he said a dark chapter. But yeah, it's an adverse circumstance affecting childhood. So is death. So is having a parent that has a drug or an alcohol problem, right? But the question is, how many of those do you experience? How much resilience you have? That's the question. Because people can go through the divorce and their resilience brings them through. We hope that this court will reverse and remand. Thank you.
Thank you very much.